Whoa, 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 whoa. So even worse, she had a 13-year-old blow into the machine? I don't know which is worse. You telling me that, yes, is that what I did, or you lying to me?
And Lori Yaki, Assistant Public Defender, with and on behalf of Ms. Threet, who's approaching. Ms. Threet, could you say your name for the court?
That's with Threet.
So, Your Honor, within the last couple days, Ms. Threet has sought an assessment for treatment. She completed the assessment. I have the paperwork here. I have the letter here. Based on the assessment, she's been recommended to participate in the intensive outpatient program through Henry Ford Health. Again, I have this documentation here. She is scheduled to attend individual treatment on the 2 days that she's not doing her intensive outpatient program, which is scheduled for 3 days per week. Additionally, Ms. Fleet is doing meetings every single day as a part of her recovery. I would ask, Your Honor, obviously the bond violation is very concerning, is very serious.
Okay, yeah, go ahead. I'll listen to everything, but
I would ask if the court would consider converting her Soberlink to a SCRAM tether to ensure that she's getting 24/7 supervision monitoring to ensure she's not drinking.
Jackie, you do realize that not only did she blow numbers, but then decided to have someone else blow into the machine for her.
Yes, Your Honor. There's no minimizing.
This is a very important moment in the hearing. Judge Simpson is separating an alleged bond violation from a violation that has actually been admitted. The report says Miss 3 drank alcohol and then had her 13-year-old child complete the Soberlink test for her. But the defense has not admitted that those claims are true. That is why the judge offers a hearing. Before making a final decision, the court must give the defendant a chance to challenge the allegations and require the prosecution to present evidence. The defense also has a credibility problem. Asking for stricter alcohol monitoring and offering a treatment plan may show that Ms. 3 wants help, but it does not explain the alleged attempt to get around the current monitoring system. A SCRAM ankle monitor could track alcohol use around the clock, but Judge Simpson must decide whether any monitoring device will work if someone is willing to break the rules on purpose. Notice that the judge tells Ms. 3 to be careful with her answers. He is warning her that admitting the conduct could prove the violation, while denying it against strong evidence could make her look even less trustworthy. The big question is this: should she admit what happened and ask for leniency, or should she request a hearing and make the prosecution prove exactly what happened? That choice could determine whether she gets treatment or remains in jail.
I understand. May I have a moment to verify with her, Your Honor?
Yep.
Your Honor, may we briefly approach?
I don't know what good it's going to do, but you can come on. Record should reflect we've had a bench conference in this case. You're supposed to say, Michelle.
The only other thing I wanted to request that I forgot to mention at the bench conference is if the court is inclined to revoke her bond, I would ask if there's any chance the court would allow her to be released to an inpatient treatment program with the tether, as clearly the root cause of both the underlying case as well as the bond is an issue of substance use. Again, she has dealt with enormous trauma. She's a survivor of domestic violence. She left an abusive relationship where her ex was convicted. And I think in November or shortly before December, which is the alleged offense date here. So there's a lot of circumstances surrounding here. Understandable that the court and the people are concerned for the community, but I would ask that this not be a case just held in jail without the opportunity to get inpatient treatment.
Ms. Feltes.
Your Honor, the people at this time would request the court revoke the defendant's bond and do not grant her a release to treatment. The underlying offense in this case is an operating while intoxicated third offense. Her priors are from 2011 and 2016. In this case, there was more than one call to the police reporting the defendant's bad driving behavior. She was eventually located by Michigan State Police troopers crashed. And when they had contact with her, she admitted to drinking. Eventually, a search warrant was obtained for her blood, and she was found to have a blood alcohol content, of 0.258. She was incredibly intoxicating, putting the community at risk, and is now drinking on bond. And as the court correctly pointed out, having a 13-year-old child flow into that Soberlink. I do not think she is in a position where she's capable of making good decisions. And I do not think that she is a risk the community can tolerate. I'm asking to revoke the bond, hold her without bond, deny her a release.
Anything else, Ms. Carter?
Your Honor, the only other thing I would say is I do think it would be adequate to protect the community if she's not driving, if she has a SCRAM, if she's in treatment, especially if she can't leave.
I can't trust her. I'm just going to be upfront. It is going to be very hard for me to trust somebody that this court releases on a Soberlink, can't comply with the Soberlink, drinks, and then to try to save herself because she knows she has to do the confirmation below. She puts a child to do that. Incredible. I will adjourn our probable cause conference May 14, 2026, 9 a.m. I'll also adjourn, since there's no admission or anything regarding the bond violation. I'll adjourn the bond violation hearing to also that date. At this point in time, the defendant's bond is revoked. Defendant's remanded to the Washington County Jail.
Judge Simpson's decision is based mainly on public safety and trust, not on punishing Miss 3 for the original charge. She is accused of driving while intoxicated for a third time. Prosecutors say her blood alcohol level was 0.258, that she had previous drunk driving convictions in 2011 and 2016, drove dangerously, and caused a crash. Those allegations alone raise serious safety concerns. The court also heard claims that she drank alcohol while out on bond and tried to avoid detection by having her child complete the Soberlink test. If true, that suggests she intentionally violated the court's conditions instead of simply making a mistake. The defense presented several reasons for leniency. They explained that she was attending intensive outpatient treatment, individual counseling, daily recovery meetings, psychiatric care, and was dealing with past domestic violence while raising 2 children. But Judge Simpson focused on one key question. Can she be trusted to follow court orders if she is released? The judge said he could not trust her. Because of that, he decided that another monitoring device would not be enough to protect the public. The violation hearing was postponed because Miss 3 did not admit the allegations, and the court has not yet reviewed the evidence. Even so, the judge still had the authority to revoke her bond because bond decisions are based on future risk, not just whether a violation has already been proven. Could sending her directly to a secure treatment program have been a better option? The defense believed so, but the judge felt that the alleged deception made that option too risky.
Excuse for justification. The only thing I can do is present our plan moving forward, which the therapist has a psychiatrist. She does have mental health diagnoses, so she does need medication. She has her psychiatrist she's working with. She has her therapist she's working with. It took her a minute to find the right treatment to address the needs that she has. She is a single parent of 2 kids. They do rely on her tremendously. One is 3, one is 13, I believe. And
So even worse, she had a 13-year-old blow into the machine?
Well,
I didn't ask her. She's free.
Oh, whoa. Is that what happened? Be careful how you answer it. I don't know that there's a good answer, but you better be careful how you answer it. Because I don't know which is worse. You telling me that, yes, is that what I did, or you lying to me?
I, at this time, Your Honor, I'm asking if the court would convert her to a SCRAM tether and mandate that she
drank and then had a child blow into the Soberlink.
I understand that's what the violation report says, Your Honor. And
does she admit to that violation or not? I mean, if she wants a hearing, we'll have a hearing. Court calls the case, People versus Justin Thomas.
Bring it over for the people here.
Brian Bowling on behalf of Mr. Thomas, judge, who is approaching. State your name for the record, please, Justin.
Justin Thomas.
Judge, when it comes to the the probable cause conference, I'm asking that we adjourn that. I'm still trying to get some discovery video specifically. And then I'm prepared to address what you're holding in your hands.
Yes, go ahead and address that.
All right. So he didn't report for the Soberlink until today. He has it currently right now. He went over to community corrections before coming here. The reason for him not having it before was that he was unable to pay for the shipping costs to have it sent to him directly. He has no resources financially at this point in time, Your Honor. But he does have it now. He lives in Pinckney.
St. Clair Shores.
Oh, I'm sorry. I thought I've been addressed in Pinckney. All right. He lives in St. Clair Shores. I'll have to get an updated mailing address for you.
Well, then he needed
to find even better, I guess. But for my
point, but he needed to find a way down here. He doesn't get to.
And Mr. Thomas and I had that discussion, Your Honor, that
he's been released, and almost for a week he
did not have transportation to get here, Your Honor.
Could have walked by that time.
It was a very difficult situation getting him here today once the Zoom grant was revoked. But he did make it here today. He has the Soberlink. He did test at community corrections today. To my understanding, that was negative. And he's prepared to comply with this court's bond order for purposes of testing moving forward, Your Honor.
Well, it can't work. This wasn't even just an issue of him not having the shipping. He wasn't calling people back. He wasn't completing his whole intake.
We did complete, my knowledge, Your Honor. He wasn't returning calls. Again, like I said, Mr. Thomas and I discussed that. I don't expect the court to have any further problems with him at this point in time. He does have the device. He's holding it here. You got to return calls when people.
Why weren't you calling them back? I mean, I don't understand this.
He works nights, Your Honor. I think when he was trying to make the return calls, there was times where community corrections was closed. Again, that's something we discussed. There is a bit of may we approach briefly?
May.
Okay, thank you. Thanks for the bench conference, Your Honor. I have nothing further to add on the record at this point in time. Like I said, based on him having the Soberlink now, I would ask the court to continue his bond and then new probable cause conference date, or would be so willing.
Probable cause conference will be set for May 21st, 2026, 9 a.m. At this point, since he's on it, I'm not going to do anything. But I want you to understand something, young man. If you miss one blow, I'm not hearing any uses from it.
Oh, no.
Am I clear?
Yes, you're clear.
Bond will continue.
Thank you, Judge. Outside real quick, I want to get that new address.
These two hearings show how Judge Simpson looks at different types of bond violations. In Ms. 3's case, The court heard allegations that she drank alcohol while on bond and tried to avoid the Soberlink test by having her child complete it. Combined with the reported .258 blood alcohol level, dangerous driving, a crash, and 2 prior drunk driving convictions, Judge Simpson decided that she could no longer be trusted to follow the rules while out of custody. Her bond was revoked, even though the alleged violation itself will be decided later at a separate hearing because she never admitted it. Mr. Thomas faced a different situation. He did not complete his alcohol monitoring requirement on time. His attorney explained that he had financial problems, transportation issues, worked night shifts, and had trouble contacting community corrections. Those explanations were weakened because officials said he had not returned phone calls or finished the intake process. However, Mr. Thomas came to court wearing the monitoring device, reportedly tested negative for alcohol that day, and showed he was ready to follow the court's orders going forward. That gave Judge Simpson a reason to continue his bond instead of sending him to jail immediately. The lesson is simple. Judges do not only look at whether a rule was broken. They also consider the type of violation, how the defendant responds, and whether they believe the person will follow the rules in the future. Problems caused by money or transportation can often be fixed. But conduct that appears dishonest or puts the public at risk is much harder to overlook. Do you think Judge Simpson made the right decisions in these 2 cases? Let us know your thoughts in the comments. If you enjoyed this courtroom breakdown, be sure to like the video, subscribe to the channel, and turn on notifications for more Real Courtroom.